Good morning, Your Honor.
Yes, sir.
Hope you had a nice Thanksgiving.
You too.
Thank you, sir. So, as the court recalls, this was a violation of probation. The last court proceeding, Mr. Dumont admitted violation. The state wanted a sentence for a danger hearing. If the court recalls, Mr. Maurice, who had spoken to the people at Evolutions, indicated that the reason for the violations were, in one instance, the battery pack from Miami, where they have a location, had not been forwarded in time to the Broward location, and the alarm went off. On other locations, either it's a two-part apparatus. There's the ankle monitor and the square apparatus. You bring with you two alerts if you don't bring them down together. On the other occasions, what happened was I left it in this room and got medications, or you get a drink of water, and left the portion of it. So that's essentially what happened in this case. So our position is, in view of that, and I'm sure Mr. Maurice would again say the same as he said last time, is that Mr. Dumont was not very smart with what he did, but certainly in terms of any change in circumstances, he's not dangerous. He never left the facility. And he's extremely sorry we felt the board would pass the case. It's not going to happen again. But that's the reason that the alarm went.
And we're sent, the idea is, I still need to hear from Mr. O'Connor, but you want me to send him back to Evolution and the bed is available for him?
Yes, he's
We
doing
confirm
very
that?
well. Doing very well, Judge. We're hoping that they can pick up the problem where he left off. It's been how long, 2 weeks?
What are your thoughts, Mr. O'Connor?
I mean, we're set for a data hearing today. I don't know if he's admitting to the violation. We need to go through the process of. I haven't been in court, so the last hearing, I don't know if that colloquy was done where he admitted to the violation. I would ask that we hear that before Your Honor hears argument regarding the danger hearing, and Officer St. Louis is on with regards to that.
I have a note from 1121 admitted to violations.
Okay.
Consider reinstating after danger hearing.
So the colloquy was done and everything.
Yes, I just don't see the forms uploaded.
Did
You filled them out, right?
Yes. Okay.
I think
This one, because I didn't see it in Odyssey, so I just wanted to make sure
I
procedurally.
think it's just a oh, here, let's see, there's something, there is a disposition that says adjudicate and sentence deferred to 12-1. But I don't see the corresponding
As long as the colloquy was
form.
done and the admission was entered, I have no issue doing that. I just wanted to make sure that was done for Your Honor, her testimony or argument. But
Yeah.
I would be calling the probation officer who's on scene right now.
Okay,
And Judge, we're
Yes.
hoping it'll be a withhold, not an adjudication, a withhold.
okay, okay.
But don't.
The court previously withheld, correct?
Yes.
Okay. Officer St. Louis, would you raise your right hand for me and unmute your line? Do you swear that the testimony that you'll be providing is the truth?
Yes, Your Honor.
Would you state your full name and spell your last name for the record?
Anna St. Louis, SAINT, space LOUIS.
Go ahead, Mr. O'Connor.
I'm St. Louis. Can you hear me okay? Officer St. Louis, excuse me.
Yes,
Hi, were you the probation officer for Jaydes Dumont?
yes.
And when did you begin supervising Mr. Dumont?
Mr. Dumont was released, I believe, in August, if I'm not mistaken. Give me 1 second. No, I'm sorry, October 22nd. He was released to Evolution.
And were you the probation officer that instructed him on the conditions of probation?
Yes.
And which office do you work at?
I work at the Miami-Dade office, 11-4, located in Miami Gardens.
And what were the circumstances regarding Mr. Dumont's violation?
He has several alarms in regards to he is walking away from his device. He's not charging the device.
Okay. And how many violations were there?
If I'm not mistaken, I believe I submitted an amended violation, so there should be about 40 alarms he is in violation for.
And that's within what time frame?
Oh, there are different time frames. Usually, at night.
And what dates, if you're aware?
It started on October 23rd. It continued on October 24th, October 25th, October 27th, October 28th, October 31st, November 2nd, November 3rd, November 4th, November 5th, November 6th, November 7th, November 8th, November 9th, and November 12th, and November 13th.
And at any point during these incidents that happened with the GPS gun alarm, did you speak to him at all regarding the violations?
Yes, I've spoken to him multiple times, in person, over through his device. I've contacted him and I've instructed him many times, the issues he's having with his device and possible solutions to alleviate the alarms.
And how did those conversations go, in your opinion?
In person, he gives me a blank stare as if nonchalance is no response. And over the phone, he explains that he's not leaving the facility, and he's explained that it's not the issue of him leaving the facility, it's the issue of him walking away from the device and not charging it. And he will say that he will do better, but the alarms continue.
Are you able to determine if he leaves the facility if the GPS alarm is not on him, or the GPS monitor is not on him?
I'm able to see if he leaves the facility or not. But the issue is our device is a two-piece device. One's around the ankle and one's it's a telephone device that he have to carry with him at all times because one speaks to the other. Once he walks, if he leaves the telephone device down and he walks away from it, we are notified that alarm generated due to that reason.
Were there any alarms generated that told you that he was leaving the facility?
No.
What was your recommendation regarding sentencing with regards to the violating?
Ooh. I understand Mr. Dumont is in treatment. This was a tricky issue due to the fact that he is in need of treatment. But I clearly don't believe GPS will work with him, only of the fact that he is not in compliance with the GPS rules. I recommended jail and hopefully community control with probation to follow afterwards.
Do you think that he's amenable to non-incarcerative sanctions? In other words, terms of supervision from the court?
Well, I haven't had the case long enough to supervise him to really say that if he is in compliance, will be in compliance with probation. The issues we only had so far was with GPS, but I believe due to the amount of alarms, I believe some type of reprimand is needed so he can understand the severity of the issues here.
Thank you. No further questions. Thank you for appearing, Officer St. Louis.
Mr. Cohen?
Now, Mr. St. Louis, he is now in fact been punished for not complying with the prerequisites of the alarm. And you agree that he's been incarcerated now for at least 2 weeks, correct?
Yes.
All right, now that having been the case, that seems to fulfill one of the concerns you had about punishment. But to get back to the main issue here, in terms of whether he's a danger to the community, he never left that facility, isn't that correct?
Yes.
Okay, so what he did is he essentially, I think on one occasion, if I'm not mistaken, the alarm alerted because the battery pack wasn't charged, is that correct?
Yes.
Okay, and on the other occasions, apparently he hadn't taken the second part of the device with him, which resulted in the alarm going, is that correct?
Yes.
Okay, so what this really is a failure to comply with some of the requirements that will be required of him while he's under treatment, which was the reason that the alarm went off. This internal problem that was created by him leaving a portion of the device behind in his room, correct?
Yes.
Okay, so you understand that, you know how old Mr. Dumont is?
No, but when I met him, I believe he's very young. I believe his date of birth was in 2006, if I'm not mistaken.
Okay, so that makes him 19 years old, right?
Yeah.
And you're aware of the studies that show that a juvenile's brain and purposes of criminal violations does not necessarily evolve at that age to a point where someone with a more adult realization of life would comply with the conditions that are required by probation officer. That's correct?
I would object to that question, Judge argumentative. I mean,
I'm asking if she's aware.
Overruled, I'll allow it.
I'm sorry, can you repeat that question for me, please?
Yeah, you're aware of studies that show that when it comes to criminal punishment issues, adults' brains are more developed than those of juveniles.
Yes.
Okay. So the bottom line here is you believe that this gentleman who made these very bad decisions is amenable to treatment if he continues his treatment, as long as he stays in that facility, would not be a danger to him. And if he
Are you asking me if he would be a danger if he remains in the facility?
and comply with all of the conditions that you require.
No.
No one, I'm not understanding.
Are you asking me if he would be a danger to
I'm
the community?
asking, no, I'm asking if you believe that he is capable of complying with these directions now that he's learned a hard lesson and spent these 2 weeks in jail.
I'm not confident that he will be able to comply with GPS, only of the fact that he was instructed and spoken to on multiple occasions, not only by myself, but by other officers. And it shows no improvement of him putting an effort to alleviate these alarms. I'm not too sure if GPS will, the issue of the GPS will be resolved if placed back on probation with GPS.
Okay, you're not sure, but you don't know for sure because he may have learned a hard lesson, correct? People do learn lessons from mistakes, right?
Yeah, he
And
may,
people make mistakes, right?
yeah,
Okay, thank you, ma'am. And,
you're welcome.
Anything further, Mr. O'Connor?
no,
Any other witnesses you want me to hear from?
Just
from the state.
do you want to hear from Mr. Dumont? It's really a sentencing.
It's entirely up to you.
We have a moment, Judge?
Sure.
Yeah, I'll just put Mr. Dumont on there, sure, but that's.
Mr. Dumont, would you raise your right hand? Do you swear or affirm that the testimony that you'll be providing is the truth? Would you state your full name and spell your last name for the record? Go ahead, Mr.
Can I
Cole.
proceed, Judge?
Yes, please.
Right now, just get to the bottom line on this, Mr. Dumont. You ever leave the facility at any time during these bills? And on one occasion, I think you were transferred from Evolution's location in Miami to Broward County and the battery pack was left behind? Okay, and that was the battery pack to alert on that occasion? And on other occasions, you left your jail cell to get, not jail cell. but-
Jackson, Your Honor, leading.
I didn't finish the question.
Let me hear the question.
Sure. And on other occasions, did you leave your room to get the water or anything of that nature? Okay, that caused the battery pack to alert, is that correct? Or device to alert?
Yeah.
What can you, and you admitted these violations, is that right? You have to answer that. Okay. What can you tell the court about your intent to follow all directions of your probation officer from this point forward and to continue your treatment of evolutions without violating any conditions?
You know, that the way I kind of see it while I like, when I was going to go answers. There should be a lot of, more.
So you have no intention to violate any court order at this point? Okay, now how are you doing it?
It's not like it's too much, doing good, treatment was good. Yeah, it's a good connection, just more about it, understanding about it.
Okay, have you been taking all your medication?
Yeah.
And are you thinking more clearly now? Okay, do you feel you're improving? Do you feel that jail will help you in any way in this case? Do you feel you continue to improve while getting treatment?
You gotta answer out loud.
I have nothing.
Mr. O'Connor?
No.
Okay, Mr. Dumont. That's a whole lot of violations that you had. If the court, well, the court's going to hear arguments from the parties, but what assurance can you give the court that there won't be any further violations?
So I have not really around the facility and downstairs to get my meds and bag because I would come around my house. Instead of having to fix my pants, I'm kind of like living on the pants. It's gonna be a lot better.
Okay. Arguments?
Your Honor, at this point, the VOSC statute is very clear. I know that it's called a danger hearing. The argument is that he's not, quote, a danger. The case law and Florida statute is very clear that if someone is not amenable to non-enforcement sanctions, then they are considered a danger, pursuant to Florida statute. Every step of the way, Mr. Dumont has proved that he's not amenable to any kind of non-incarcerated sanctions, even dating back to when he was on pretrial release in division. When he was placed on supervised release and absconded. I mean, the arguments that he didn't leave the facility, I don't think are appropriate. The Wallop family testified, Your Honor, on October 17th at a very lengthy downward departure hearing, and their primary concern was the fact that the listed victim on the case was in fear of the defendant. They wanted the GPS monitor. Everything that went against the prison sentence revolved around the GPS monitor. And that is the substance of the violations before the court. This isn't a 1 time, 2 times, 3 times, 4 times that the alarm went off and then he had a conversation with the probation officer. This was a situation where for months, the alarm kept going off within a short amount of time after we resolved this case. He now scores 42.5 months Florida State Prison with these violations. It was a very serious offense. And he was given a very, very generous resolution. I don't believe that him not leaving the facility is enough to say that he's not a danger to the community. Like I said, the danger statute is very clear that if somebody is not amenable to non-incarcerative sanctions, then they are considered a danger. I don't believe that Mr. Dumont has shown any kind of compliance with his condition of the probation. Has gone to treatment, but if the GPS monitor is not being abided by, then there's really no sense of security that the victims can have in a case like this. And I would just ask that Your Honor consider your notes and the evidence that was presented on October 17th. I don't think that we can trust Mr. Dumont to abide by a GPS monitor. He was spoken to by Officer St. Louis according to the testimony regarding compliance with the monitor. And he still was not amenable. And Officer St. Louis's recommendation was a prison sentence. So I would ask that Your Honor revoke his supervision and sentence him to the bottom of the guidelines. The state's not prepared to agree that he's not a danger because the state does not believe that he can abide by the conditions, any kind of conditions that the court would place on him while he's in the community.
So Officer St. Louis's testimony, and I wrote it down, Judge, was that he violated on October 23rd, 4, 24, 25, 27, 28, 31, 2, 3, 4, 5, 6, 7, 8, 9, 12, 13. Those are 15 days. That's about half the time that he was there. So it wasn't like he was violating every day. He was violating a substantial period of time, but about half the time. So it wasn't as if he wasn't complying every day. The second thing is he's 19 years old. I know the court is aware of the studies that show the development of juvenile brain and how that affects criminal conduct. He never left the facility. Our position is no different now than it really was on the day he admitted. He never left the facility. alarm alerted on one occasion, just as I said, because the battery pack was left in Miami when they transferred from the Miami facility to the Fort Lauderdale facility. The others, he never left the facility at all. And either when he went down to get a drink of water or just left the living quarters, that's when it occurred. So was it an extremely unwise decision that he made, doing what he did? Yes. But does that, under the circumstances of a 19-year-old kid who now has been punished? And by the way, the probation officer felt that jail would be appropriate to send a message. Jail has now sent the message. He now knows what happened if he doesn't comply. He goes to jail, and the whole situation blows up. So I don't think that the record under those circumstances supports dangerous fun. I do think it sent the correct message. I do think he's been punished. We're hoping he can be returned to evolutions where, as you heard from him, Judge, he's doing well. He's taking his medication. I can tell you, based on my contact with him, that he's a different person in terms of what he was when he went in, which was quite out of touch with reality, to a point where he's now confident and it's improved and is getting much better. So he's been punished, Judge. And the shame of it all is that he was doing well and is doing better and will continue to do better. He's not a lost cause at 19. So we don't believe that the record has demonstrated dangerousness. We do believe that a message has been sent. Hopefully the court will find that he's not a danger at this point and can be sent back to evolutions for treatment, knowing that if he violates, he's looking at 42.5 months in Florida State Prison, which I think he understands now, and that he would then become a convicted felon, which would be the end of any possibility he has for having a productive life, and that he gets a chance, but he doesn't get another one if he comes back to this court. So we're hoping that one of those circumstances will find that he's not in danger and send him back to evolution so that he can continue that program.
Brief rebuttal, Judge. The message that was sent was when he violated his pretrial conditions before the case was resolved and he was in jail. The message was when the probation officer told him that he needs to charge the GPS monitor. That was the message. This is a violation of probation that resulted in points on his score sheet. This isn't just a message that is being sent. A violation is still a violation, whether he was compliant half of the amount of time. There should be no violations at all, period, while on probation. The court cannot say that he's not a danger and then give him leeway as far as quote mistakes or anything with regards to that. A violation is a violation under Florida statute. This was a violation. He was given plenty of opportunities and plenty of messages to start abiding by the conditions of probation, and that did not happen. So this is a violation. This isn't a message or a mistake.
Okay, I'm going to find that Mr. Dumont is not a danger for purposes of the VFO statute. Mr. Dumont, you've, I hope, have learned something through this incident, and I hope I'm crystal clear that now that you've heard how serious it is, and you've heard from your probation officer, that any violations going forward, this is likely the final chance that the court is going to give you. Whether Mr. Maurice speaks up on your behalf or your attorney speaks up on your behalf, I think everybody has been crystal clear. You have had about 40 violations. If there's one more, you are likely looking at prison. I just hope you understand. For today's purposes, the court is going to reinstate his probation with all of the same terms and conditions to go back to the evolutions program on a GPS monitor, to not leave the program, and to abide by all of the terms and conditions of the GPS monitors. Did you have any questions, sir? Mr. Cohen, you might want to follow up with evolutions.
His father and mother are here today.
And have they done that? We know that the bed is available and he can go right back. Sorry, you're not certain?
Drawn out,
Not certain if you go back out. Oh, better.
I think
Okay.
Mr. Maurice is going to.
Are you gonna call Mr. Fada? Who are you calling? Yeah, okay. Let's come back on, I want to see how he's doing.
Yes,
Let's
sir.
do December 29th.
Yes, sir.
What was that? December 29th,
What time is that, Judge?
9:30. You're welcome to appear by Zoom.
Yes, sir. Appreciate that, Jimmy.
All right. We just, so your disposition is gonna say reinstate same terms and conditions. I think we need,
Defendant was ordered back.
yeah,
You have to do a written order, man, that's fine.
yeah, I'm gonna do it right now. As soon as Robbins speaks to them, can you do a short order for me that has the contact person that's picking him up?
Yes, sir.
And that he'll be released from custody on a GPS monitor to go custody to the Evolutions program?
Yes, sir.
All right, I just want to make sure that the bed is available.
Thank you, Judge.
Okay, just give me a couple minutes, guys.
Township council supposed to get services in place because they present to you. So they were looking to, within this bill 30 days, we should be dealing with this list. The court was looking to it as the concern of where the was for sure. And if they're, if they're going to leave, they're on. Okay. Alright, got it.
Or 012
He has another case.
Nice job. Just make sure that you are thinking it's not.
25 and 1279. Yeah, it was an ad charge. I don't know if it's filed yet. It is not filed. It's from earlier this year. I don't know if he's being involved on it. State.
Supervision.
Okay.
This edition, I know. Your Honor, you want to do a short order for this or not?
I just did the not a danger order.
Okay,
What order do you want me to do?
I don't know.
We need to do an order for transport if the bed is available. That's the order I'm talking about.
Consider the constitutional solution, we said.
That would be good, but I just want to make sure that the bed is available before I put it in the dispo.
Better availability.
Okay.
Okay.
Robbins, what did you find out?
It's all going checking system right now.
Okay, all right. Okay, hi, Mr. Lawrence.
Judge, how are you?
Good, how are you?
Good, Judge, thank you. Joe Lawrence from Public Defender's Office, I have Mr. Curtis Brewer.
Hey,
I don't have any pages in front of me.
18,
I have a document. Sorry, sorry.
18, go ahead.
Thank you, Judge. This was here for APD evaluation that was ordered by the court. We have that here today. I think if anything we need to do with this, order it obviously ordered by this court sometime before. This was just for the APD evaluation we have, and we already have a future court date. In front of Judge Holman as well for next week.
In front of Judge
Judge Holman.
Coleman.
Yes, 12/8/25 in front of Judge Coleman, we can just. Consider the hearing held and he doesn't have a piece of it here.
Did you want my copy of, you have it?
That's one thing, so.
All right, we'll set his case back before Judge Coleman. Okay,
12/8.
Yes, really.
did I already do an order that he remains competent?
Correct. There was already an order entered back, I think, in October, September.
Okay.
We had order in.
This was an APT evaluation.
Right.
She also did a competency.
Okay,
She's very thorough.
very good. Thank you. Did Mr. Clayton Burns have a cupcake for his birthday? Did you have a cupcake yet? Oh, it's your birthday. Okay, go ahead.
He's a morning cookie.
Kamani Williams.
Yes,
He's on page 10 of the docket, Jen Rowley for Kamani Williams. He's in custody. He's in the front row. And he has a letter for your honor that is very touching. I showed it to the state. May I give it to you?
sure.
Particularly the last paragraph on page 2 is what is very important. And I'll stop talking.
Girlfriend, it felt so good. I opened up everybody. Yeah, I just want that somebody else from my system up for this one.